Hey everyone, welcome back to LMIpodcast.com, Lawyers, Mediators International Show and Podcast, where we talk about the law to educate both professionals and everyday people. So with us today on the show, we're going to be talking to Harshitha Ram. She is a international recognized arbitrator, mediator, and ADR thought leader and educator who has handled hundreds of complex disputes across the U.S. and internationally. Harshita, how are you doing today?
Hello, Mac. I'm good. How are you? Thanks for
Good, good.
having me here today.
Awesome. Thank you so much. Ashita, you have served on multiple national and global panels, and you are president of the Global Arbitration Mediation Academy and a distinguished JAMS Fellow and an ICC YAF Rep F of North America. So many people know you as having a sharp legal insights, cross-cultural fluency, and practical problem-solving skills. In this episode, we're going to talk today about the mediation trap, specifically why settlements collapse post mediation. So, thank you again for being here to talk about this topic. First off, why is this even a thing? How much problems can this cause, the mediation trap?
That's a great place to start because the mediation trap actually surprises a lot of people. Settlements actually collapse post mediation because mediation is designed to create agreements and not necessarily create durable agreements. So, for that reason, I can say during the mediation in the room, emotions settle and pressure eases to some extent, and parties are focused on compromise. But once they leave the mediation room, once they leave the table and return to business, that's when reality sets in. So there is legal scrutiny and there is internal approvals and so many other things going on. And that's where cracks begin to show.
And as many lawyers and mediators know, many mediations end with handshakes and optimism, yet disputes still surface. What are the warning signs in the room that a settlement may not survive once the parties leave the mediation?
As I said, the post mediation effect, the problem is that those cracks that I just mentioned can be very expensive. So a collapsed settlement doesn't just restart the dispute, it oftentimes escalates the dispute. So that's when parties lose trust, they incur additional legal fees, and sometimes also end up in a worse position than before mediation ever happened. Um, so this isn't a rare or a minor issue. It's one of the quiet reasons why disputes linger long after everyone thought they were resolved. And it is definitely a thing because mediation is emotional momentum, not structural certainty. So in the room, everyone wants peace. And as I said, outside the room is when the reality sets in. So, what as mediators, our goal is or should be to build an agreement that survives that shift and it really doesn't fall apart that easily. So, sometimes these agreements can fall apart spectacularly, and the damage here can be real. So, expensive higher costs, broken trust, and the disputes even come back more entrenched than before.
Yeah, so you've identified that vague terms and poor follow ups are major culprits in mediations. Can you give us an example of a vague term that looks innocent, but that might actually destroy a deal later?
Absolutely. And this is where deals quietly unravel. So, a classic example of a term, or a vague term, I should say, is the parties will use best efforts to resolve any outstanding implementation issues. So when you look at it, it sounds cooperative, very elegant, but in reality, legally, it's almost empty. So here, what are we looking at? Best efforts? So what does that even mean? Best efforts to whom or by whom? And whose standards really apply to these best efforts? Or by when? And what is the timeline here? And what happens if someone says, hey, I tried, and the other side did not agree? So these are some vague terms that we should be very careful of. And I've seen entire settlements collapse over language like that. Because once there is a disagreement, there's nothing concrete to enforce. So if you want a business focused solution, then it's better to avoid these vague terms. And another vague term can be payment related ones, like payment will be made within a reasonable time. So this is very common. And reasonable to whom? So are we talking about 30 days, 90 days, 60 days after a certain period? So these are terms that that actually become the next dispute, right? In many cases. So in mediation, these terms feel harmless because everyone is aligned in the moment. But once lawyers come out of the mediation room and present the settlement agreement to the finance teams or boards for review of the agreement at a later time, that's when typically these vague phrases become pressure points. And that's oftentimes is when the deal breaks. And if a term cannot be enforced, it isn't a compromise, it's a future conflict.
Exactly. And personally, I've had experiences this as well. I do a lot of divorce mediations, for example, and sometimes we'll put some terms in there that we hope people will follow, and they say, "Oh yeah, don't worry, we'll follow it." But for example, visitation will be as mutually agreed. But as soon as they leave, the predictions proven true. The vague terms that are not specific just results in conflict. People have to then come back to mediation or go to court. So you're trying to make sure people don't have these kind of problems. Try to do it right the first time. So you advocate for contract style terms and contingency planning during the sessions. How do you pivot parties from emotional resolution to this kind of technical drafting without killing the mood?
That's a great question. The key is not to pivot away from the emotion itself, but ideally, you want to use the emotion. So, emotional resolution is actually the window where good drafting becomes possible. So, when parties feel heard and ready to move on, they are more open to clarify. That actually creates space for clarity. Now let's get technical. Let's go to the contract drafting. No, that's not what I say. Instead, what I say is let's protect what we've just achieved. So that makes the difference. The framing matters. And contract style terms aren't about mistrust, they are about preserving peace. And oftentimes, they translate technical drafting into very human questions. So I go something like, what could realistically go wrong after today? Or something like, what would make you regret this agreement 6 months from now? So when parties answer those questions themselves, the contingencies write themselves. So the mood only dies when drafting feels adversarial. But if clarity is presented as a shared insurance policy sort of a thing, then something that prevents future conflicts, and parties really recognize that and usually lean in rather than pull back. So the good mediation doesn't end emotion, it channels it into something durable.
One of your proposed solutions is something you call post-mediation check-ins. How does a mediator do this without violating their neutrality, or become an indefinite reference?
Yes, so mediators do post mediation check ins, but the effective ones do so in a limited, intentional, and ethically sound way, because you don't want to cross the line of neutrality at any point. So it's not supervision of the case. It's not about reopening the dispute. It's a brief, agreed upon touch point focused solely on implementation. So when mediators avoid check ins altogether, it's often out of caution, not because practice is improper, but when this check in is done by a structured design with consent and with clear boundaries. The check ins actually protect neutrality rather than threaten it. Supposed mediation check ins aren't about staying involved in the matter or with the matter itself, they are about making sure that resolution actually takes hold.
So, can you explain the concept of consent awards as a follow up protocol? When is that appropriate versus a standard settlement agreement? Can you give a clear explanation to this?
Sure. A mediator does not have the power to issue an award, so usually it's the recommendation or the settlement agreement, as we all know. But mediation is a consensual, non-adjudicative process. So strictly speaking, there is no such thing as a mediation consent award. That said, mediation can feed into a consent award when the parties are already within or agree to enter into an arbitration framework after. So, which means a consent award is what happens when parties usually take the terms they've already agreed to and ask an arbitrator to issue them as an arbitral award. And here, nothing new is decided, no one wins or loses. The arbitrator simply records the parties' settlement in the form of an award with the parties' consent. So the practical difference is enforceability. So a standard settlement agreement is a private contract, and if someone breaches it, the other side usually has to start a new lawsuit to enforce it, or it's a different dynamics altogether. But a consent award, on the other hand, can often be enforced directly, sometimes even internationally, without relitigating the dispute altogether.
Okay. And if you had to name three things mediators or lawyers, counsel, could do differently on the day of mediation to prevent post settlement collapses, what would they be?
Well, if I to name three things and not complicated ones for mediation, I'll start by saying first treat the settlement like the dispute hasn't ended yet. So, which means the biggest mistake happens the moment everyone relaxes in the mediation room. So that's precisely when the agreement needs the most attention and discipline. So before anyone leaves the room, the deal should survive a hostile reading by someone who wasn't there in the room at all, a neutral third party, right? That is a very good practice to have a new reading of the settlement agreement itself. And second is to replace goodwill with monotonous writing. So every obligation should answer four questions: who does what is the timeline, how, and what happens if they don't. So if any one of those is missing, then the dispute isn't resolved fully. It's deferred, literally. And the third aspect is to decide today, right now, at the moment, how tomorrow's failure is handled. Hopefully not, but not emotionally, not informally, but procedurally. So, whether it's a consent award or a scheduled, structured, designed check in by the mediator or a pre agreed return path, the party should lead knowing that if the deal stumbles, the process will catch it. So, when mediators and counsel do these three things, settlements stop depending on trust and start depending on the structure and the design of the mediation or the process itself. And the design is what makes agreements survive real life post mediation.
Gotcha. Well, Harshitha Ram, thank you so much for talking to us today about the mediation trap and why settlements sometimes collapse post mediations and what we can do to avoid those problems. Okay, so if people want to learn more about you, they can go to your website. That's harshitaram.com. Pretty simple. And so I am screen sharing it just so the public can see and they're able to follow up with you and check you out. So until next time, this video and all the other recordings, including any other ones by Harshita, will be on lmipodcast.com. All right, Harshita Ram, thank you so much for coming on today.
Thank you, Mac. Thanks for having me here today. Thanks.